So I think I'm going to approach this question in a very holistic and kind of maybe oversimplistic manner, because I think you need a practical approach because of the rapidity in which the landscape, particularly with the advent of AI's accessibility to everyone, because AI has been around for a long time, has grown and continues to scale at the rapid rate. I think we're at a crossroads for sure in terms of how technology as well as the law are going to interact with each other, particularly as the scale, the volume, the rapidity of the growth of AI is such that I think it's impossible for regulators and policymakers to actually keep up. You can issue as many standards as you want, but if the actual modality, the product, the services that are being generated are moving as fast as they are, I think it's not humanly possible, at least, to keep up with that. So I would say I'll first kind of address the challenges a little bit, and then I'll try to propose a few solutions which are kind of practical. So I would say the biggest challenge from an IP legal perspective is ownership and authorship and creatorship, inventorship, right? The very definitions of when you have autonomous creativity involved in any process. I think the very question that's being turned on its head, which is a struggle for the courts as well as for regulators, is, who is an owner? And where would you be defining that? Because ownership means value. So value, why is value important? Well, why do we innovate things in most cases? Why would, R&D and investment dollars be put to work if there was no incentive per se? So I think policy to a large extent is going to be driven by, where the value creation is going to be and who can be attributed to, the ownership with respect to that value. And that ownership, of course, then clarity in that ownership perspective leads to regulators and governments and policymakers to be able to define those very, very fast-moving targets. So I would say the key challenges, as I mentioned, are attribution, ownership, inventorship, as well as authorship. What is original? How do you, is using a prompt, that's a big hot topic now, is prompt engineering and, prompting creative. Should an owner who has been very good at prompting an autonomous system be given ownership? Can he own that IP that comes out of that? So these are hot, in the moment topics, right, that we're all wrestling with. Those are kind of the challenges. How do you define these things, in real time, right? And I think until the courts get involved and, the litigation continues, I think it'll be quite difficult to land in any one place. But I think it's a fair sort of point to agree that ownership is going to be a key sort of aspect of any challenge that's going to be applicable to IP.